Good morning. Are you Matthew Wadsworth?
Yes, ma'am.
And Mr. Wadsworth was previously in court and entered a plea of guilty to the second-degree felony offense of aggravated assault. Pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Yes, sir.
Are there any additions or corrections?
No, Your Honor.
Not from this one.
All right, Mr. Rojas, you may proceed.
Yeah, Judge, it's the cap of 8, the agreement, I think it's a cap of 8, and just based on the criminal history alone and the PSI, it looks like
It looks like you did a very good job of getting that agreement.
that's kind of what, not that I did a good job, but I think that may be doing a.
A guilty plea opens the door to a second-degree felony and a life already written in ink. An 8-year cap sounds merciful, until the judge studies a criminal past that never stopped. Then the court turns to the man himself, and everything changes at the midpoint.
However, Judge, there are some things I'd like to point out. If you look at, and I'm talking about his felony criminal history, the first page of his, I guess, rolling into the second page of his felony criminal history, most of those offenses happened in 2002. So he seems to be getting those in bunches. Those happened in 2002. He got sentenced in 2001. In January of 2002, they all happened.
Right.
Got revoked in 2003 on all of them. I think he did 60 months on all of them. Got some more in October 2002. Then after that, he goes in 2019 when he picks up some more cases. And from 2019 to this present case,
From after the 2002 and to the 2019, there were seven additional felonies.
Yes.
7 additional felonies.
yeah.
Go ahead.
And then from 2019 to now, at least, he's able to stay clean. So he tells me that most of the time when he's committing offenses is when he's off his medications. He's been back on the meds now in jail. It's helping him. He's able to think clearly now. We talked about this, and if the court's even going to consider probation, as pointed out in the PSI, the only way he's going to get probation is with safe P to get help with his drug issues. He understands that. He recognizes that. He's willing to do that. He's hoping that you give him a chance to do that. And even as he pointed out by the probation officer in the report, he's indicated to them that he's tired of this lifestyle. He's tired of being in handcuffs. He realizes he needs help just to make his life better. And he tells me he's ready to make that change, and he does have some statements to make to you at the appropriate time.
All right, go ahead, sir.
I only wrote this because I get really nervous.
Sure.
So I said, this letter is to ask you for some help. I'm a drug addict. Oh no. Basically, listen, man.
A plea deal is set, history exposed, and hope quietly hangs on medication and probation. Years of crime clash with claims of recovery as the defendant asks for one last chance. But when the judge adds up the numbers, the second half turns brutally final.
Then I did really good. The Ritalin, I went from straight ups, farting in class, thinking it was funny, picking my nose and eating it, all that stuff. I thought it was, I just was bad. They put me on Ritalin, I went from straight ups to straight A's. I was sexually abused. My parents were drug addicts. I went to prison. You guys forgot something. I hope it don't hurt me, but I got beat up. I had a robbery in 1992. When I got out from that robbery until 2000, when you started, 2002, yes, ma'am. I stayed out of trouble again because I was on medication. It's been my whole life. It's been the pattern of my life. I'm on my medication. I'm a great guy. I'm a journeyman electrician. I'm a father. I'm a grandfather. I spend time with my kids. If I'm off of them, and the reason I got off of them and this offense happened is I was hearing voices. I thought my roommate was holding my girlfriend hostage. It says I hit him with a bat, but it was my walking cane. It wasn't a bat. And I did hit him, and I felt horrible because I found what was going on. But in my head, our house burned down, dogs died, and I just kind of went crazy. But I did stop. I did tell in 19. I said, I'm tired of this. And I'm gonna stay on my medications. When the house burned down, all my medications went with it, my truck, my tools and everything. And I was just barely making it. And I honestly thought my roommate was holding my girlfriend against her will and hostage. When we started fighting, I was losing. And I said, if you do give me the chance, what I need is some help staying on my meds. Because I start feeling like I'm doing better sometimes. And then I stopped taking them. When I stopped taking them, I hear voices, and I can't tell if it's mine or if it's somebody else, or I can't.
And I appreciate what you're saying, and I feel like you are sincere in what you're saying.
Okay.
The problem is you're 51 now, 52?
51.
51.
Fixing to be 52.
And you know you've had these issues.
Yes, ma'am.
You've been given opportunities, and you know I need to be on my meds. And even if I give you a probation, it's only for so long. At some point, you have to stay on your own meds, and you can't require someone else to force you to do that and take a chance with society and the community of you hurting someone else. I'm not sure, but I honestly think that you have the worst criminal history I've seen.
I even said that to Mr. Rojas. I said this.
You have 19 misdemeanor convictions. You have 20 others that were either filed, dismissed because of pleas on the other cases. So technically about 39 misdemeanors. 21 felony convictions. 21. I know, wow, right?
I'm not.
You still have one pending in Indiana. And in addition to the 21 and the one pending, you have 16 others that were dismissed because of plea agreements, and things like that. So that's 38 felonies. And I get a lot of this was from '02, and a lot of it was in the same big scenario.
19 of them was in one.
But it didn't stop then. You were put back on probation in 2017. So not that long ago, given a probation, it was revoked. So you were given an opportunity. Mr. Smith?
I've completely stayed out of trouble since then, though. Not one single incident.
Well, you had 2017 an unauthorized use of a vehicle felony. 2018 an obstruction of justice in Pike County.
Yes, ma'am.
2019 an escape. That's the one that's pending. Hold on.
Oh, I'm sorry.
And then another later in 2019, maintaining a common nuisance of a controlled substance or something like that in Indiana. So the last thing is 2019, which is, in the big scheme of things at your age, not that long ago.
I know, I understand.
Mr. Smith?
Judge, I would point you to his account of probation where he said the part about the baseball bat is not true. A dresser fell on top of him.
I saw that.
He's still not accepting responsibility.
I hit him with the cane.
Hold on, don't speak over. I let you talk, so don't talk over anyone else, please.
I believe probation is absolutely right that jail time and probation has not been a deterrent for him. He's not made probation. We would ask for the 8 years TDC.
Mr. Wadsworth, again, like I stated before, to Mr. Rojas, the fact that he was able to negotiate for you a cap of 8 years on a second-degree felony with your criminal history, there's part of me today that was considering not even accepting this plea agreement. Because I think with your criminal history, personally, I think it's ridiculous.
I have to understand.
So I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find that you entered your plea of guilty. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. There's help in prison for you with medication. It's going to be up to you when you get out to either change your life if you really want to or not, and you'll have to do that on your own. All right, good luck to you, sir. You can go back with the bailiff.
Matthew Wadsworth stands before the court already convicted, the weight of an aggravated assault charge hanging heavy in the air. The judge opens by acknowledging a plea deal, capped at 8 years, a limit that quietly signals how severe the danger behind this case truly is. Prosecutors lay out a criminal history stretching back decades, a pattern of arrests, releases, and returns that paints a life stuck on repeat. Wadsworth's attorney argues medication matters, insisting stability appears when his client stays treated. The idea of probation surfaces briefly, almost hopefully, before reality intrudes. Then Wadsworth speaks for himself, nervous, shaking, reading a letter meant to explain a lifetime. He describes untreated ADHD, addiction, abuse, prison violence, and moments where medication seemed like the single fragile barrier between order and chaos. His account turns darker. Hallucinations. Voices. A belief someone was being held hostage. A violent confrontation he insists spiraled from fear, not cruelty. He lists everything he has lost: a burned home, dead pets, vanished tools, and the fragile routines that kept him grounded. For a moment, redemption feels possible, balanced delicately on honesty and regret. But the judge responds with numbers, not sympathy. Dozens of convictions. Felonies stacked on felonies. Probation failures. Missed chances. Age without change. She explains the court's duty is not only to him, but to everyone else who might be harmed. Medication might help, but trust has been exhausted. In the end, the gavel falls hard. 8 years in prison. A deadly weapon finding. No appeal. Limited future rights. As he is led away, the court leaves one final truth echoing behind him: change is still possible, but it will only happen if he chooses it. The silence reminds everyone that justice balances mercy, fear, and responsibility long after the courtroom doors close forever. Today, Matthew Wadsworth stands before the court already convicted, the we.